Sri Nasir may, in the meantime, give the details of the existing legal heirs who are to be substituted.
Highly ordered.
Oh, LCR is there.
First, there were two cases. One of the LCR is here. Both were qualified. One was filed by the mother, another was by the wife. One LCR is already here.
और बोला बोला ये ठीक है सर अगो टू ऑर्डर it है अपन बदलाई दिन बड़े टुटे है डिले हो ना ओके Yes.
Yeah, please, Your Lordship. In the morning, I've made a mention for adjournment
Yes, yes.
on behalf of L. Gogoi.
Yes, it's for orders. Why is it for orders? Yes, to be undertaken by the petitioner as per not yet been. You have not taken steps, madam.
Okay, we will take fresh steps.
Office note. Anna, seen the office note dated 3/5/2024. Made in terms of the order dated 22/3/2024 of the Learned Laws Ima Court. Full stop para. Miss, your name?
Tinlum.
Tinlum Learned Counsel for the applicant petitioner praised for and is accordingly granted a week's time to take fresh steps for service of notice upon the respondent number 1 by registered post with AD as well as usual process through the office of the Learned Civil Judge Junior Division, Dhemaji. Yes, take steps. 1 week.
On behalf of L. Gogoi.
Doesn't matter.
Obliged, Lord.
Huh? Tinlum. Tinlum. Oh. Yes. Item number?
12 point.
Yes.
My lord,
You're for the respondent.
yes,
Who's for the appellant?
my lord, even on the last day, the counsel for the applicant.
None appears for the appellant on call. Whereas GMTH,
Yes,
Learned Counsel is present for the respondents. Full stop. Para, even on the last occasion, that is 26/4/2024, none was present for the appellant. Full stop. Para. In the interest of justice, a final opportunity is granted to the appellant, directing listing of this case on 14/8, 14/6, next Friday.
highly ordered.
Full stop. This court, however, makes it clear that in case of further non-representation, appropriate orders will be passed.
Highly ordered.
May I please, Your Lordship? Lordship, kindly allow us to take press step through paper publication, my lord.
You have taken Dusty.
We have taken, my lord, but they are not served, my lord. That's why, my lord.
If you have tried to serve, file an affidavit, we'll deem it to be served.
No, my lord, company wants to serve through paper publication, my lord.
The present IA
Yes, ma'am.
is at the stage of service of notice. Full stop. The connected appeal along with the IA were filed in the year 2019. Full stop para. Ms. L. Sharma learned counsel for the applicant has however submitted that in view of the aforesaid position, comma, the notices may be directed to be served by way of paper publications.
On vernacular language, my lord. Assamese use करते हैं.
Para, considering the above, comma, let such notices upon the respondents be served by paper publication, full stop. Such publication is to be made in one issue of the Assam Tribune and another issue of the
Vernacular language.
Dainik Akham, and are to be routed and are to and the notices are to be vetted VETTED by the registry of this court, full stop. Let the next date be fixed on how soon can you get the publication done, madam?
My lord, after vacation, my vacation.
Fixed on 19th of July 2024, and the said date be clearly reflected in the notice to be published, full stop. Prior to the next date fixed, comma, the applicant is also required to file an affidavit annexing the copies of the newspapers, concerned newspapers.
Obliged will.
Item 14.
It is the lordship. Lordship, we were supposed to take justice service on respondent 2 and 3. We have taken for 2, lordship. 3 is from Manipur. That report we haven't yet received. That's why we couldn't file the affidavit, lordship.
Okay.
So we need 4
Okay.
weeks time.
Okay. MSRD Mazumdar, learned counsel for the appellant, submits that so far as the dusty service upon respondables 2 and 3 is concerned, comma, the respondent number,
2's dusty report we have got.
respondent number 3 being from the state of Manipur, comma, the confirmation report is yet to be received, full stop. The learned counsel accordingly prays for and is granted further 3 weeks time to obtain necessary instructions / file affidavit in this regard.
Highly obliged, sir.
May I please, Lord?
Yes.
I need, my lord, 1 week time to file the petition of respondent number 3, my. He has died, my lord. Earlier, the council of respondent number 3 informed for this honorable
But
court.
that was in
My lord.
December 23.
My lord, yes, my lord. My lord,
You
we are late.
abated in the meantime.
My lord, we are late to collect the details. Already we have received, my lord. By next Monday or Tuesday, we will file, my lord.
The order dated 19/12/2023 reflects that the opposite party number 3 had passed away in the meantime. Full stop. Para. SHRI T. Sheikh, learned counsel for the applicants, however, submits that steps are yet to be taken. Full stop.
By next week, we will file.
Steps are yet to be taken and prays for some more time. Full stop. Para. Matter is accordingly adjourned by further 2 weeks.
Obliged.
Lordship, office noted 5/6/24, LCR have been received. Kindly fix the hearing.
Notice is served.
Lordship,
Okay. Which office note, madam?
5/6/2024.
Your name?
A. Hussain.
Miss A. Hussain, learned counsel for the appellant has submitted that not counsel for the appellant, comma, by referring to the office note dated 5/6/2024 has submitted that the lower court records have been received. Full stop. Para. The order dated 9/11/2022 has already recorded the service of notice upon the respondents. Full stop. Para. The matter may accordingly be listed for hearing in its turn.
Made Peter. My lord, this is the matter relating to the violation of,
Oh, yes, yes.
yes. So, my lord, I think it's high time that this should see the finality. Your lordship. has-
Nothing has happened in the meantime.
Sorry?
Nothing has happened in the meantime.
No, nothing. Nothing. My lord, what I find is, they know it well.
When
They-
Mr. Mahanta is there, we thought that matter would be.
Well, the lordship, we tried, lordship tried, but nothing transpired.
Somebody must be preventing you in trying.
Well, probably their own mindsets. Because
think-
when it comes to,
One trust from you, your side, I think will bring the matter to an end.
well, provided,
Some advice
provided other side is not in my touch, I cannot.
that too, Mr. Roy is always accommodative.
So, the way things moved when we met and we at your lordship initiative, that of course didn't result. Therefore, I am not that hopeful, but nonetheless, well, always it is advisable, more particularly in a case of givenness.
Yes, the case is for contempt. It's not for substantial rights.
Yes,
He has it for any
And
substantial
they are-
rights. We adjudicate, we come to a conclusion.
yes.
Contempt, the conclusion may not be very palatable to either of the parties.
Exactly. It can go anywhere, but then it has to be ultimately, well, let the trust out to give a final warning to the sides that, look, this is how the law operates. That is the
Now, what about
ultimate-
little you remember, they had set up some defense that this is not the correct interpretation, or the allegation is not based on correct factual position. It's some parking, isn't it?
Yes, yes, well,
That
the
corridor.
corridor.
That
The
is
common
in
passage.
respect of a common passage.
Common
The
passage.
common
What
passage.
is common passage that has been mentioned in the suit, Schedule D. So your lordship has to see that whether it's a violation of common
know.
passage or not.
That is what your lordship ultimately wanted to know.
What has happened to the main case?
It's-
Somehow or other, it is not reaching that stage. So that it can be finally decided.
Why don't you
Because
insist?
they have got the absolute result, absolute benefit they are enjoying.
No, no.
So they are not
the-
interested to go ahead with it. My instruction
No,
is,
no, no, that is absolutely
my
wrong, my lord.
instruction is this.
No, no,
That is absolutely wrong.
the subject matter, the main lease is still pending. This is an offshoot, a very minor offshoot
That
for
should have
contempt.
proceeded. Yes, that should have proceeded.
You
But
proceed
on
and you
some
find that.
more, ultimately, can you see the situation? The plaintiff has already got the relief which he wanted. He is rather enjoying it by misinterpreting the order of this
So
honorable
what the-
court, by violating the
Let him
undertaking
prove, my lord,
given
that
by
it is
him.
vi-
Now, what is the stage of the suit?
So-
Yeah. Evidence is not started, I think.
Evidence will start out. with the-
Evidence is not started.
Not yet.
Why? Suit is of which year? 19, I think. Or 18. Is it 18 or 19?
18, yeah? 15. Suit of 15.
Why evidence is not started?
I don't know, my lord, because let me, I'm taking instruction.
My instruction is that on some ground or other, tests are being checked, not proceeding. Civil suit, so many formalities, so many things, so many questions raised at times. They are taking and the interest is, I am only suffering. I have been prevented. I am not, I am.
Now we'll direct this suit to be completed. Brought to its logical conclusion within a time bound frame.
Yes. A time frame may be given, my lord.
By that time, well, till kindly see the order of this honorable court. Till today, I am obeying my own commitment. This is a commitment given by us, both sides, but they have not. They have misinterpreted it to an
Now,
extent.
okay, now tell us to you whether you're pressing on this today a hearing, not today, immediate hearing, or you want to avail some more.
Well, my instruction
I'm
is
leaving it to you because it's an own matter. Every time
own
you
matter,
cannot
but
just.
every time it is coming.
It's not a question of
But
passing the
I-
buck.
I-
Somebody will
I-
have to take the burden. Either we
Yes.
or some other.
Exactly, my lord, I want that, my
Your
lord.
lordship will decide the issue, my lord. That we are on that.
Whether there is a contempt or not.
Yes,
But may hear it next week, anything.
even that is very short
Or
time, my lord.
even today. if
Even
your
today it
lordship-
can be
Today,
completed.
today we'll rise slightly early. So there are
Oh,
some
yeah.
administrative works.
Yeah.
Today it may not be possible.
Let it be on Tuesday then, my lord.
Tuesday, many matters have been fixed. We
Wednesday,
can
my
have
lord.
it on Wednesday.
Wednesday, my lord.
Wednesday
Wednesday
পারা
কি
যাবে না
হয়?
একটু না জানিব দেখা আইডিয়া আছে নাকি ওয়েডনেসডে ওয়েডনেসডে বহুত ম্যাটার ফিক্স করা আছে ওয়েডনেসডে
This will not take much time, my lord.
Not take much time. Almost
that
lordship
is
available.
your perception.
So we'll try, we'll come.
On the
I'll take Miss.
We have had preliminary hearings of this matter.
Yes,
It
yes.
went 2 hours,
2-3 occasions.
2-3 occasions.
Yeah.
My lord, I'll say that I will take my lord, hardly my lord, 20 minutes, my lord.
Lordship is aware about the facts. That's the positive aspect. Now we'll place the remaining part, including the law. Touching upon the conduct of the parties, that is the main thing now. For me,
Conduct already,
me.
Leonard Single judge has said, my lord, what is the
For
conduct
me.
of the parties?
for me, my obligation is to place
One has.
the whole thing involving the conduct, how they are behaving. So let's see what way it goes.
Yes, Wednesday, my lord. Lordship will upgrade the matter, my lord, at 2 o'clock.
This is not a very important matter that
I
needs
know.
upgradation.
I know, my lord.
But until
Two parties fighting for a passage corridor.
Yes.
My
And,
lord, the
and
passage is, my lord, the front portion is a common passage. And my land, my place is not a common passage. That has been defined Schedule D in the title suit, my lord. One cannot go beyond that, my lord.
Well, and, all said and done, ultimately lordship will have to.
now what is your difficulty now? You have difficulty in parking your vehicle.
Yes, I am
Even now?
outside. Well, I am out. I am on the main road. I am on the main road. He is enjoying. His initial suit was that it is me who is preventing. Court said-
Are you planning to make the main road a part of your compound
Well,
by kind of adverse
had it
position?
been possible, probably by now he would not have left the opportunity.
Since how long are you parking your car there?
From the order of this honorable court.
You have converted into a garage.
The suit is, we filed a violation of injunction, my lord. That is pending for hearing that injunction application. And secondly, we filed amendment of the suit. my lord.
No, did you,
And that's-
when you had said, was there any sincere effort in resolving
There
this
was
kind
a-
of, these are very trivial
Let-
issues.
Let me place the fact, my lord.
Parking of vehicles
No, no,
and
let me
corridor
place the fact, my lord. The-
and the
two
status of
sides-
the parties involved doesn't look good. You
Yes,
have come up in
that's
a
correct, my lord.
contempt and we are
we
deciding
know
a
the-
contempt.
Lordship will see the correct fact, my lord. The property, two friends bought it in
No,
front
we are not going into the merits.
and on the backside of me.
Wednesday will try.
That's
On the
the-
Thursday one.
But,
On Thursday.
Thursday.
Wednesday I have some.
Thursday will try, but we will not give preference to this matter.
Well,
We will not give.
lordship will at least see that.
We'll treat this as a matter as a normal matter and
That's correct, my lord.
it's not a
We
matter of
cannot
interest.
claim by that way.
Matter you should sit and settle. Very small issue.
Small issue, my lord.
Some little bit of give and take. What else is required? Okay,
Certain measures were suggested by media so that court can adjust.
I think we had an in-camera proceeding also.
Yes. But my learned friend's client is not agreeing to it.
No, Lordship, once the Lordship delivering the order, then you know, Lordship, what happened. I don't have to explain that.
Okay. As agreed to by the paucity of time may not allow the matter to be considered properly. Full stop. Para. In the as agreed to by the parties, list for consideration on Thursday.
Oblige.
26.
For further consideration, Lordship.
Lordship,
Further, we have not said.
Lordship 13 fixed. 13, my lord. I'll be out session, my lord. On 12, my lord.
Well, Wednesday, Mr. Mohanta has some difficulty, I think. 12, is it possible, Mr. Mohanta?
Let us try.
12.
12.
Yes,
12. Okay, 12.
Oblige.
because I am having some burden.
Okay, we'll accommodate, no
Yes.
problem.
Oblige.
It is a Lordship. Lordship will pay his office note dated 1/12/23.
112.
Yes, Lordship.
Yes, please.
We were supposed to serve notice on respondent 5. Unserved notice insufficient address. So Lordship may allow us to make dusty service, Lordship. Because only for 5 it is waiting. This I, Lordship.
MS R.D. Mazumdar, learned counsel for the applicant, who by referring to the office note dated 1/12/2023 has submitted that dusty service may be permitted upon the said respondent number 5, full stop para. You are for,
Respondent number 4, Your Lord.
and other respondents served, madam?
Other respondents serve, Lordship.
Okay,
1 to 4.
Para? having
Sorry.
considered the aforesaid prayer has been considered, full stop para. Liberty for serving dusty, for serving notice on the respondent number 5 by dusty is allowed, which is required to be routed through the registry of this court. Let the next date be fixed on, we'll have it on 17th of July, 2024. Full stop. In the notice accompanying the dusty, comma, the next date is to be clearly reflected. Full stop. The applicant is also required to file an affidavit prior to the next date regarding dusty service.
Highly obliged.
Mr. Chaudhary, for which matter?
I'm waiting for one matter.
Order matters.
Order. Actually, my lord, we have prayed for little clarification of an lordship's order. Item number 38 and 39. If today it is, it can't be done Monday, can I?
Today we'll rise at 4 o'clock. But who is for the other side?
Other side, state government, my lord, forest department.
State what review matter?
Not review, my lord, small clarification of.
By
the
this
law.
court?
Yes. That, my lord, I mean, that forest matter, Nameri matter. Well, there is a confusion has arisen. Your lordship has interfered with the impugned action and has said the interim order was made absent.
Okay.
Now, interim order was only 10 persons were permitted to enter. Now they are interpreting the order that it amounts to only 10%. Whereas our entry itself was prevented. That is the clarification.
If the other side is there, we could have, or maybe some other day.
On Monday, my lord, if it is not.
Monday, very difficult.
All Wednesday, my lord.
But we can try on Wednesday.
Yes, Wednesday.
Any state council here who can inform, who is appearing otherwise?
Huh?
Oh, forest department,
Yes,
department, anyone? Forest
Mr. Gogoi was there. I say. Whether,
The judgment, I think, pretty old, I think.
yes, quite sometimes, because now
No
we
appeal
have,
has been preferred.
now, no, they have no appeal has been
Okay.
preferred. In fact, my lord, pursuant to lordship's order, our, the arrangement was terminated. Then the learned single judge made an observation that you get a clarification, then it will be, everything will be okay. That is how we are before.
What has been terminated?
Original agreement between us.
Okay, that is the subject matter of challenge.
That other writ.
But how will it have effect in your present fresh writ petition?
No, I think the honorable court was of the view that if this matter is passed out, then it will become easier. Because they are preventing our entry is being prevented.
Mr. Bhattakur, yes, you have instructions today or Wednesday. If you are equipped with the instructions, we
Huh.
otherwise on Wednesday we can have.
Lordship,
You will appear or who will appear?
Lordship, I'll appear. Instructions are not there as such, but the petition we have filed an affidavit
You have filed objection?
in the main petition.
In the main writ
Main
petition.
writ.
No, we're not on that. He is seeking a clarification regarding the interim order which allowed 10 persons.
Huh.
Now, the contention is that since the entire action has been interfered with,
Yes.
that restrictions will become, that was the interim restriction.
Yes.
Now that,
But taking advantage of that, that order has been passed. That's why the other thing is,
which order has been passed?
if your lordship will kindly permit me, please take the IA number 1156.
Order of allow only 10.
Yes.
Item, page?
Page number 81. It starts at page 80. Please come to page 81. Para 8.
Yes.
It is crucial to note that Honorable High Court did not issue any mandamus permitting petitioner association to resume its activities in EcoCamp, except for the interim order which was made absolute in the fine. And they're taking advantage of this. The interim order stipulated that in the meantime, respondent number 4, that is so-and-so, shall allow entry of 10 persons authorized by the President and Secretary of the Association into the camp area with specific
No, that
direction.
was at the time when we're in season of the matter, when we
Yes.
thought that we'll examine.
No,
Now the
end of the
examination has
matter,
been done.
the very offense report has been interfered with. That means,
Examine the matter has been dealt with,
Yes.
interfered with.
so because that line is there, interim order is made absolute, that is why they are taking advantage of. And your lordship's observation is at page
And
70.
then, thereafter, what has happened?
Now, my lord, when we challenge this order, this particular order of 12/6/23, then during the course of hearing, this aspect has come out. Therefore, the honorable single judge was of the view.
Okay. Oh, this is the subject matter of challenge in another case. Okay. Mr.
Therefore-
Bhattakur, what do you say?
Lordship, the proceedings have ended the earlier writ petition.
No, see, if this view of ours been tested in any higher court and matter would have been reversed, or even at pending, then matter would have been different. Now we have passed a final view in the order dated 33/2023, and the impugned actions have been taken, have been interfered with. Now, can you construe the last part to mean that only it will be restricted to 10?
Yeah.
I don't think that will be a correct interpretation. I think we'll modify this. Third, K. N. Chaudhary Leonard, Senior Counsel for the applicant also heard SHRI I. Bhattakur Leonard, Standing Counsel Forest?
Forest.
Standing Counsel Forest for the opposite parties, full stop para. The instant application has been filed in the in connection with WPC 3745 of 2021, which was disposed of on 30/3/2023. Full stop. Para. Shri Chaudhary Jalal Senior Counsel has submitted that wide the aforesaid judgment and order, comma, the action of the respondents in the form of an offense report number CH35, whereby the members of the petitioner association were termed as accused qua offenses under sections 24A bracket में capital A, comma 24B capital B and 25 of the Assam Forest Regulation 1981 and articles and under articles small 2A page 67 से लिख लीजिए, comma and 3 capital B of the Forest Conservation Act 1980. Full stop. This court, by the aforesaid judgment, has interfered with the impugned action and has held the same to be unsustainable in law and was set aside. Full stop. While disposing of the writ petition, comma, the interim order was made absolute. Full stop. Para. The London Senior Counsel has, however, by referring to a communication dated 12/6/2023, has submitted that the department has taken a view that since by the interim order only 10 persons were authorized, 10 persons who were authorized by the association would be allowed to enter, comma, enter the area in question, comma, the same restrictions are being imposed. Full stop. Para. The Senior Counsel has also submitted that the aforesaid action has been put to challenge separately in WPC 4/888 of 2023, wherein an observation has been made to seek clarification on the aforesaid aspect, and accordingly, the present application has been filed. Full stop. Para. The maintainability of an IA in a disposed of petitions is no longer res integra. Full stop. Though a fresh cause of action cannot be raised by filing an IA in a disposed of matter, comma, clarifications can be sought for, as has been held by the Honorable Supreme Court in the case of A.S. Ansari versus Indian Airlines. What was the name? Ansari versus Indian Airlines.
Yes.
And what was the earlier case?
Even that Brahmadat, that was a
Brahmadat.
subsequent cause of action, para 10.
Brahmadat has been explained, but
Yeah.
Ansari, full stop. Para. This court is of the view that when the entire impugned action was held to be unsustainable in law and set aside by the by the judgment and order dated 33/2023, the observation that the interim order be made absolute cannot be given a restrictive meaning of allowing only 10 persons to enter into the area in question, full stop. Such restrictive meaning would be against the direction contained in the judgment and order dated 33/2023, full stop. Accordingly, the matter stands clarified that the direction which was given in the form of an interim order stood merged with the final order, and the entire action of the respondents being held to be unsustainable in law and set aside, the applicant would be allowed to have all the benefits of such pronouncement of this court. I accordingly stands disposed of. What is the other one? 1336.
Oh, there are two writ petitions, my lord. Same.
The writ petition will be different, number will be different. 1336, same, huh? WPC alag hoga isme.
There were two writ petitions, so there was a common judgment.
WPC will be 614 of 2021 isme. 1336. Okay. Both will be allowed. All right, Adina lage. Rest, today we have to have some works. Today, except any matters which are very urgent. Rest will give dates.
Lord.
Yes.
Item number 23, Lordship, landlord tenant matter, that other side has appeared, maybe fixed for admission, Lordship.
We'll give dates, don't worry. Any matters where interim order is still today?
My lord, item number 58. Madam, it is urgent.
What is the matter about?
About it, there is a COVID test should have, COVID has granted. Arising out from the partition suit. Partition of one of the, during pendency of the suit, COVID was, will was executed.
Your Lordship, I am for an opposite party. We'll file the affidavit in opposition in the mail.
Well, file it soon.
We'll file because
But
we have received on 30th of May, 35.
Okay, he has just entered appearance. Let him file the affidavit.
Let us file the affidavit.
Okay. On a item number,
Item number 58.
on a request made on behalf of the respondents, matter is adjourned by 2 weeks
2 weeks.
to enable filing of affidavit in opposition.
God bless.
Okay, you're not filing an affidavit? No, okay. No.
The first time there it is.
Mrs. You have filed your affidavit?
We have filed affidavit.
Okay,
My lord, we want to file reply to that, my lord.
you want to file an
Yes.
affidavit? Okay.
My lord, in
Meanwhile, my lord, as per the order dated 8/2/24, my lord, I have prayed for the interim protection, my lord. I could not place it before this honorable court because the notice was not issued to all the respondents, lordship. My lord, may if allow, I may be allowed to place for the interim protection, my lord.
What interim protection?
Or not to give effect to the final gradation list.
Yes, lord.
My lord, I have not gone through it, my lord.
My lord, there is a
This will be difficult. This is a what you call this gradation list.
yes, lordship.
Is of 28/8/2023.
Yes, lordship.
Now we are about how many months?
24.
8, 9, 10 months down the line.
Yes, lordship.
What has happened in the meanwhile?
My lord, there is no, my lord. What happened is, my lord, before 1 year, my lord, this gradation list are published. And if at all the vacancies are available according to this gradation list, my lord, there will be recruitment on that basis. Promotion will be based on that, my lord. My lord,
I have been informed by the officer. My lord. Some of them are private respondent is going to be retired 1.5 months. After 1.5 months, 6 months like that. At this stage, my lord, interim order is, my lord, it will hamper them.
my lord, we
Because,
have
my lord, gradation list, otherwise he is a senior, but definitely he will get it. Others are there, not all, my lord. Some of them, my lord,
So,
retiring
I'm
after
asking
what
it
we.
because I have not been able to follow this this gradation list. Yes,
The final gradation list
No,
that
no.
has been published, my lord, 17/6/2015.
No. This is
Page
this
number
is
82.
8/2023.
Page number 82, my lord.
No, just wrong.
Yes.
You're trying to say that once you are in the list,
Yes, sir.
in seniority, you are absorbed in the regular police force.
Yes.
That is your case.
Yes, ma'am. My lord, when this particular organization was formed, my lord. at
No,
that-
instead of staying it, then we say that if there is any superstition of the petition, that will be subject to further orders of the court. We are not staying it then.
My lord, I want to place something, lordship. This is a combat rules, lordship. My lord, there is a general procedure of promotion, my lord. I will straight away come to point number D, lordship. The committee shall prepare a select list in order of preference, and the total number of such names shall be equal to the number of vacancies that may arise in respect of the percentage allotted for the promotion quota in cadre and ex-cadre post of the rank during the period of approximately 1 year thereafter. In every case, while drawing up the list in the committee changes the order of seniority of any person in the rank of Subedar or supersedes anyone in that rank by omission of his name, the committees shall record in writing the reason for such change or supersession.
So where were you in the earlier position? Your earlier position is what? How is the position changed?
My lord, actually, there is a brief fact of the case that I have to state for that, my lord. Because my absorption was done by the order of this honorable court.
Correct.
When the order of this honorable court was done, my lord, the order says that on the month of 2000, on the year 2018, I have to be absorbed. Sorry, 2008, my lord, I have to be absorbed. That was the day when this particular organization was formed. My lord, at the initial stage, I was in the Assam tea plantation force. This was a force which was developed by the government of Assam to meet the requirement of the tea plantation at that period of time for fighting the extremist issue. Then, my lord, what happened is that since we were doing the same work as that of the Assam police, that is why we said that we want this similar equal pay. So accordingly, our organization, our welfare committee approached this honorable court by filing a civil rule, my lord. And after that, the honorable court observed that since the kind of duty we are doing, so we should be either absorb or rehabilitate somewhere else. So after this order, my lord, what happened is though there was no specific period fixed for that, my lord, but even though the order was passed.
That is 2014 judgment of the court.
2002 judgment, my lord.
2002, where is that?
My lord, may kindly come to page number 21. Out of the relevant portion, if lordship may come to kindly page 27, my lord.
97 order.
The fourth paragraph, my lord. Page number 27, fourth line.
Paragraph number?
Paragraph number 6, fourth line. 6. Whatever the justifications and reason may have been, the fact remains that the members of the force under the direct operational and disciplinary control of the police authorities are performing what are purely state function. Even assuming the applications of the Home Guards Act to the members of the force, which is revelated is that under the Home Guards Act, Home Guards on duty are public servant and while called for duty have the same power, privilege and protection as available to the member of the police force. This court, in the case of the, there is an observation by referring to various judgment. My lord, may kindly come to page number 28, that is paragraph number 9.
No, you see, Mr. Vishnu, you have to show us that whenever you were in the Home Guard,
Yes, sir.
there was a seniority list.
Yes, sir.
And then you were superseded. That's why you are challenging, you are saying that you are challenging the 38/2023
Yes, sir.
gradation list.
Yes.
Correct?
Yes.
In order to demonstrate that you were superseded,
Yes.
in order to stay the operation. Otherwise, we can always say that since you have made the challenge, any promotions granted
Yes.
or any absorption granted by the seniority list shall be subject to outcome of the deliberation. So otherwise, what happens is everything is stalled. But unless you can show, if we can show that yes, this is the seniority list which have been tinkered with
Yes.
to downgrade you and to upgrade someone,
Yes.
then we accept your statement. But where is that comparative examination can be done? How it can be done?
Our affidavit in the paragraph 7 and
The
9.
reason is very simple.
Yes, doctor.
Let us say A is in number 1.
Yes.
He will get a promotion or sorry, absorption.
Yes.
Now we stay that. Therefore, he doesn't get it. We don't know when we hear the repetition next. Therefore, in the process, he may retire and therefore he doesn't get the benefit. He will get a notional benefit.
Yes.
Correct?
Yes.
So that is one aspect. But in the second aspect is that if you are entitled to and somebody is promoted, he can be again recalled by the order of the court. But if he is found entitled to, he gets the benefit of promotion. He continues with that. This is the difference between the two.
Yes, sir.
To stay the operation of a gradation list and to make it subject to outcome of the repetition are two different ways of looking at it.
Correct.
Please tell us if you can show the comparative examination, then it's okay. Yes, otherwise we'll
Uh,
not stop promotion.
My lord, unfortunately, in this petition, my lord, what happened is like when I was absorbed, after the absorption, only this final gradation list was done. I was absorbed in the year 2020. Now, my lord, this is of 2000, when 2021 also it was absorption list was made. But at that point of time, my name was not reflected there. But on the next rate petition, my lord, item number 45, comparison I can show, my lord, because in the year 2021, when I was given the retrospective seniority, the final gradation list of 2021, same list, my lord, which I'm challenging in the next item even. And even in the draft gradation list, my lord, in the next item, that particular period was considered. But in the final gradation list, it was completely erased. But on the other hand, serial number 9, Anukal Sinha, serial number 7,
Yes,
this particular person was given retrospective seniority. That is considered.
he is also from the same force.
Same force, my lord. We were also under the same category. My lord, if lordship allow, item number 45, my lord, I can show the comparison of it.
Yes, yes, do it. Item number 2 is 45.
45, my lord.
Yes,
45. My lord, page number 59, my lord.
yes,
59, this is the final gradation list, my lord, which was in the year 2021.
yes,
Now, coming to point, my lord, the candidates list, final gradation, 11, 12, my lord. Ranjan Kumar Barua, serial number Ranjan Kumar Barua, Mukta Bahadur Chetri, my lord, with retrospective seniority of Subedar with effect from May 2015, my lord.
correct.
Here, this is the reflection which is shown here. My lord, make the next page 63, my lord. This is the draft gradation list of 3rd February 2023.
Yes,
Page number 64, my lord. This is the draft provisional gradation list. Serial number 3, 4, and 5, my lord. That is with retrospective seniority of Subedar with effect from May 2015. This is granted. But if I come to my lord may also take note of Anukal Sinha, serial number 9,
yes,
with retrospective seniority. Now, this is the final gradation list, my lord, which I am challenging. Lordship may kindly come to page number 68.
69,
68, ma'am.
68, yes,
Yes. 68, this is the final gradation list, my lord. In the final gradation list, on page number 69, my lord, serial number 5 and serial number 6, my lord, my retrospective seniority that has been erased. But Anukal Sinha, that which I have shown earlier, lordship, with retrospective seniority of Subedar, that still remains in his case.
Yes, he's made out a case. Okay.
Will not appear again very fast there to demand. So we need to file affidavit, madam.
You file it, but he's made out a case for stay. If his seniority has been erased, then this, what do you call this, rule 15D comes into play. He's entitled to a stay. Next one. The learned counsel for the petitioner has asked for his prayer for interim relief. First off, in support of his prayer for interim relief, the learned counsel of the petitioner has referred to the provisions of clause D of Rule 15 of the Assam Home Guards Service Rules, 2020. And it is submitted that in case of any changes in the order of seniority of any person in the rank of Subedar or in case of supersession of any person in the rank by omission of his name, comma, the committee is required to record in writing the reasons for such change or supersession. Full stop. By referring to the final list of final gradation list of Subedar, which is annexed as Annexure 5 to WPC 619 of 2024, it is submitted that that against the persons whose name appear in serial number 10, 11, and 12 of the final gradation list, which was notified on 18/5/2021, their seniority with retrospective effect in the cadre of Subedar was given with effect from May 2015. By referring to the final gradation list of Subedars notified on 3/2/2023, which is annexed as WPC 619 of 2024, it is submitted that as against the name of persons at serial number 2, 3, 4, and 9, the seniority is granted with retrospective effect in effect from May 2015 and May 2018. So stop. By referring to the impugned final gradation list, the 28/8/2023, it is submitted that the entry of retrospective seniority of persons at serial number 5 and 6 has been erased, and therefore their seniority is not considered with effect from May 2018. So accordingly, stop. Next part. Accordingly, committee submitted that as per the current practice in that is being followed in the Assam Police, in terms of seniority in the provisional gradation list of Subedars of Home Guard organization, persons are absorbed in the Assam Police. Accordingly, it is submitted that if the seniority position of the petitioners is erased, they would lose an opportunity of being absorbed in the Assam Police in the current vacancies. Next paragraph. Notwithstanding that the learned additional senior government advocate has opposed the prayer for interim relief, but considering the projection made by the learned counsel for the petitioners, the court is inclined to hold that the learned counsel for the petitioner has been able to show that his seniority position in the final gradation list has been altered. Therefore,
the petitioner, he was not a regular platoon commandant. Petitioner was
Not
P.
re-
Subedar.
No, regular, on by paragraph 11, we have stated our affidavit, where not regular platoon commanders in pursuance of the order of those 17/6/2015 WPC number 3688/2010. The prisoner were put under cadre course training. He was sent to training, thereafter he come training, then he was regularized.
No, you see, I've given the reasons. If you can show us that if he is not a platoon commander, he will not be entitled to absorption. That is not the,
Not the case.
not your case.
Senior,
So therefore, if his name is in the seniority, you see, everybody does not get an opportunity of becoming a platoon commander. Platoon is how much? 12 in Assam Police?
12.
12. How much is platoon in Assam Police?
14, I think 14.
It will be 12 then. It will be 12. So, okay, whatever 12 or 14,
14 or 14.
it's okay, whatever 12 or 14. So everybody doesn't get an opportunity of being a platoon commander. Even in Subedar rank, will not be able to getting it. So, and deny that promotion to him. According to the
So we, as the private respondent, they have appeared. The matter may fix for a hearing, then our lordship will pass the order.
Let him pass, let him
Because
file an
as we
affidavit.
have filed already affidavit, our clearing our stand, my lord.
Let him file an affidavit.
Yes.
Yes.
So no interim order may be, my lord, pass, my lord.
The respondent authorities are directed not to give effect to the final duration, impugned final duration list of Subedar dated 28/8/2023 till the next date of listing. Next, the petitioner shall produce a certified copy of the order before the respondent number. Before whom we will produce?
One, two, and three. It's only three also. Director General of Civil Defense and Commandant. General of Home Guard.
Respondent number 2 and 3 to bring the order to the notice of the state authorities. And the next item,
Yes, my lord, there is an affidavit we have filed. There is an affidavit that we have filed in item number 45, my lord. With regard to paper publication, lordship, that was not filed. That was directed to be handed over to me, my lord, in 13 May, but he has not till had not handed over the paper publication. Order dated 13/5/44 item number. 45. No, no, তুমি তো দিয়ে নাই মোক। 13/5.
13?
30, item number 44, my lord. No, that is not.
Oh, no, 44 is over.
Over.
44, we have taken notice and there, you want to file an affidavit?
Yes.
Right, somewhere in that item, earlier item. The Learned Counsel for the private newly implemented private respondent shall praise for and granted time to file affidavit in opposition in the matter. How much time? Then it goes after vacation. Press for 3 weeks time to file affidavit in opposition. Next for a list on 22/7/2024.
27.
22/7. And in this next item, 45.
Yes, lordship. There is an affidavit we have filed, my lord.
Okay,
As per the direction of the Honorable Court of 9/4/24.
okay. But you should give a copy to him, Mr.
It is already served, my lord. He have already taken step and accordingly the report has been submitted. But for item, this is the first time after I have filed the affidavit, it has come.
Okay, but just give a copy to him.
Yes, please. My lord, I have submitted the copy to the connect. I have already. I don't know, 45, huh? Fine.
But this is a K. Vishwakarma as counsel for the petitioner. And Mr. T.C. petitioners and Mr. T.C. additional senior government advocate appearing for the respondents. Next one. Next, Law and Counsel with the petitioner has submitted that pursuant to order dated 9/4/2024, the petitioner has taken steps for service of notice on respondent numbers 4, 5, and 6 in a substituted manner by publishing the same in 2 local newspapers. Stop. By referring to affidavit filed on 9/5/2024, it is submitted that the notice was published in the newspaper, in 2 newspapers, being I don't know why you save ink, I don't know. It gives so much of trouble. You say one English and one vernacular. Now name you don't give. Why you are saving some ink?
My lord, page number 18 and 6, paragraph number 6, my lord. Notice published as a publication in Assam Tribune newspaper, English newspaper, my lord. And in Dainik Assam newspaper, my lord. There is
in
vernacular
Assam Tribune and Dainik Assam published on 20/4/2024. Most of the original newspapers are also enclosed there too. Accordingly, notice on the respondent numbers 4, 5, and 6 is deemed to be duly served. None appears for the said respondents. Okay. List on same date. Take back your gazette.
Yes. I oblige, my lord.
Oblige.
46.
Yes.
Meet please election. Mother, this case is all about the functioning, the way the human mind works, Mother. It's about a promotional examination to the post of the rank of sub-inspector of police. In a nutshell, Miller, if I may just indicate.
Every time a new problem arises, I get a new problem in my head.
May I just point out, Miller? It's, as I said, it's all about how beautiful a human mind is, how it functions. So for the promotion exercise to be carried out, all were eligible, no difficulties. They had to take the test, no difficulties. Everyone took the test, but the circular said that the board had a power to fix, I use the words, minimum qualifying percentage of marks, unreserved, general, whatever, SC, ST, whatever. So they had the power to fix minimum qualifying percentage of marks. As a normal man, I would think 30, 35, 40, 45. My lordships, that's how we go normally. Qualifying percentage can be this way. I think that way. Some people thought it the other. They thought 36.8 should be the cutoff mark. And I got 35.6. The thinking of that mind would be in the record, that file, that what goaded them to put that percentage as the cutoff percentage. And I say it's absolutely arbitrary. 26 vacant posts are.
It won't be.
I would address your lordships on that. I'll come to that. They come up with a step.
Because you see, I'm a person who is involved in many such recruitments.
My lord,
We don't record reasons why we give cutoff marks at so and so.
fair enough. If that be so, then the bar, the bench or the bar, whatever you call it, it stops at 36.8. My lordships, I cleared. I got 35.6 and they stopped at 36.8, and not that posts are not there. There are posts. 26 posts are there. And they indicate in everything vacant due to non-availability of reserve category candidate. I am a reserve category candidate from STP. I am before your lordship saying that if your reason is that it's vacant due to non-availability, my lordships, the page 32 for a moment, page 32.
We can't enter into that
No,
arrangement.
I'm not entering. They cannot supplement with reasons that I'm on, you know. I'm on that aspect of the matter. They're supplementing with reasons. Page 90, page 32. 32. This entire group is the list of candidates, you know, who sailed from. Now, at serial number 19, lordship sees, first page, serial number 19 is an STP with total marks 92. I turned the page and the next STP lordship sees at 24. Lordship is there. Is vacant due to non-availability of reserve category candidate. I scored 89. The halting at 92 or my scoring of 89 being not up to the mark, or that they're saying that vacant due to non-availability of reserve category candidate, things do not gel out, Miller. There had to be a reason. Now they filed an affidavit. In this affidavit, if my lord would have the affidavit, page 43, third paragraph, if I may read, of the affidavit. May I read it? As per score sheet received from SEBA, a total of 117 number of candidates could score 40% marks, that is 100 marks out of a total of 250. All these 117 were selected as general category candidates. Now, vacancies were calculated as per existing rules of Government of Assam, as per which for a total number of 11 unreserved seats, the corresponding quota of candidates of STP would be 15, STH 8, SC would be 10. My lordships, pausing for a moment, vacancies are figured out prior hand. Vacancies were never on the anvil of how many unreserved categories candidates could pass. That's the first thing which I would like to address your lordships. Whenever there's a selection exercise, be it direct recruitment or promotion, we know the vacancies, the anticipated vacancies, it may flutter here and there. But to say that 170 is unreserved cleared and calculating or computing from 117, we got these numbers that would not be in the correct canons of service jurisprudence. Number one. Number two, the second page, lordship has the chart. The cutoff for the first page, it says cutoff marks on the extreme right of right below. The first page, the table below. The extreme right is the cutoff marks. So general cutoff marks is 100. Scheduled caste, it's 90. Scheduled tribes hills is 83. And scheduled tribes plain is 92. My lordships, the entire idea of reservation is to ensure participation and no more on the lines drawn on caste system. On the caste, scheduled caste, scheduled tribe, OBC with horizontal and vertical intersections and all. Here is a case where scheduled castes vis-a-vis scheduled tribes plains, the scheduled tribes plain has a higher cut of 92 and the scheduled caste has a lower cut of 90. That again does not gel with the reasons. I would understand had they come that 92 would be the scheduled caste and 90 the scheduled tribes. I could still understand a rational thinking because they could not have fixed the percentage after evaluation of the marks. The reason is they had said in page 42, the last paragraph, they took a decision at the level, the Departmental Examination Board, which was authorized to fix the minimum qualifying.
You correct your records, the correct numbering will be page 48 onwards.
That's what I had. Anyway, internal page 3 perhaps.
It's okay.
Internal page 3. It's there affidavit.
Internal page 3.
Internal page 3, the last paragraph. The last part of that. The Departmental Examination Board, which was authorized to fix the minimum qualifying percentage of marks, as per circular mentioned above, discussed the modalities and fixed the minimum qualifying marks at 40% with the approval of the DGP Assam for general category candidates via minutes of its meeting dated 25/1/2024. My lordships, the same meeting required them to fix the marks for all. It cannot be in a scenario with any examination, whether it's conducted by the High Court, the judiciary, the executive, anywhere. If it's a selection, the vacancies must be known, number one, and the qualifying percentage you may not disclose. I do not say that they had reason to disclose, but no, in the meeting reached 25/1/2024, they ought to have reached that, yes, 40%, 36.8% would be, we'll fix it. They could have. Then, lordship, I would be on one page. But perhaps, yes, this reason was taken prior and before knowing 92. The scope of discrimination would not be there, although I would advance it. But here, may I pray that the records of 25/1/2024 be produced in the court? If they had not fixed the percentage, and then they had thought that 92 would be for STP and 90 for the SC, apparently bad, and the next man, Miller, I have a fair chance to be considered for promotion on the merit of my performance in the test. That's my case. The arbitrariness is writ large. I rest my case.
Yes, Mr. What do you have to say?
My lord, I am appearing for respondent 6 Seba, my lord. My lord, we have conducted the departmental examination only. Promotion is up to the department. We have
Introduce the record of this meeting of 25/1/2024 in a seal cover.
Lordship, the intention of the department is only to select the best candidates, Lordship. And Lordship, the examination is also already over, Lordship. The unsuccessful candidates can appear again, Lordship.
This will produce at the minutes of 25/1.
Lordship.
All sides are represented. The prayer made by Mrs. Manika and counsel for the petitioner. The learned government advocate shall produce the minutes of the meeting dated 25/1/2024, which is referred to in paragraph 7 of the affidavit in opposition filed by respondent number 5. The copy of this admittance shall be produced necessarily for the perusal of the court.
Would the law be pleased to fix a date for that?
Will it go to 17th of July?
Very grateful, obliged.
Deeply obliged, Lordship.
To the Prime Minister, I'm sorry, I'll not be able to take up any other matters.
Lordship,
The interim order is passed. You can request you can give the number to the court master, will extend the interim order. Yes.
Lordship, item 52, Lordship, contempt matter, pension matter, Lordship. Can it be on 14 or 21st?
Pension matter.
42,000, yes, yes, Lordship.
Okay, let's take note of the pension matter.
14 or 21st?
He'll take the call.
But there was an interim order operating, that needs to be extended.
That last matter, interim order passed at this and extended to the Minister.
Obliged.
Okay, I first will take note of that.
51, there is urgency list. Item 51. 13 or 14, there is a suspension matter. 51.
51. Okay, 51 also. Okay, 14. He'll give the dates.
Item 59 was for correction, my lord. Correction in the postal, my lord, in respect of respondent number 1, my lord.
50.
59, my lord.
59. Cost law?
Respondent number 1, my lord.
Okay. Who is appearing for the others? Forest and finance? IA for correction of cost title. We allow that. Respondent 1, you made a mistake. Okay. Heard-
59.
Yes. Heard Mr. D. Kalita, counsel for the applicant. Also heard. 8th Article and government advocate appearing for the state. Forest will be there. Mr. D. Goway, standing counsel for the forest department. Finance is there. Mr. Harbor Pujari, standing counsel for the finance department. And AG was Mr. Barba, Mr. C. Barba, and standing counsel for the AG. Next, this interlocutory application has been filed for correction of the cost title in respect of respondent 1. Stop. The prayer for correction of the cost title stands allowed. Stop. The petitioner, the applicant, the learned counsel for the applicant shall submit a amended cost title to the amended cost of the writ petition to the AOJ. Pending section. Upon receipt of it, shall make it a part of record of WPC 2572 of 2024 and also make necessary correction in the central registry after the matter will be listed in court.
In item 60 also, your lordship, I am seeking for correction of the cost title. Item 60. 60.
Cost title in respect of?
In respect of the title of the petitioner, your lordship.
Okay.
The title of the petitioner has been written as Begum, your lordship. It will be Khatun, your lordship.
60 is the same correction of cost title of the name of the petitioner in the connected writ petition. Allowed sense, isn't it? Here the respondents would be government is Talukdar for AG. Your name?
Tinglung on behalf of RK Talukdar.
You write her name, huh? Dazi, take her name. Appearing on behalf of Mr. R.K. Talukdar. Standing counsel for the Accountant General. And Mr. B. Govil, and standing counsel for the Health Department. For government, you will be there? Three. Just a 6 years, correspond to 3. Correction of constable in respect of name of the petitioner. About same order, correction of constable to AOG. Okay.
Please, Lordship, item number 48, some urgency is there, Lordship. Date may be fixed, so I.
What is the urgency?
Lordship, the petitioner was selected for the post of Lordship, land record assistant, Lordship. In spite of that, he was not allowed to join in the service, Lordship.
48.
8, Lordship.
Okay. 48 also.
Lordship, 47 also.
What is the urgency?
Lordship, is a compulsory retirement, Lordship.
Lordship, in this case, we have received the fairwise comments. 3 weeks time may be granted, Lordship, or fine.
Okay, how much time?
Lordship.
How much time?
3 weeks time may be granted, Lordship.
It goes after vacation then. Okay, both sides are represented. This is RDV, then CEC case for is granted. Time to file affidavit in opposition to the matter. Same shall be filed at least 2 days prior to the next day processing. Next list on 22/7/2024.
Bless.
Muscle.
57, madam. Content matter, madam. The order has been complied with.
Item
57.
57.
7.
57. Okay. Mr. S.K. Roy, counsel for the learned counsel for the petitioner, submits that that as per his instructions, the order of the court has been complied with, and therefore he has instructions not to press the matter. Mr. D. Nath, learned counsel for the respondent, is present. The matter is closed on satisfaction.
Bless.
I'm sorry to keep you waiting, Mr. Goswami, and all everyone.
Next date, Lordship, 61. Interim to continue.
Okay.